All right, I'm recording again. I don't know what happened. The system just shut down. But we're back. So we'll finish knocking this out because we got about 20 minutes before my kids got to be picked up from school. All right. So we were talking about listing price. I think when we got kicked off. So your seller is agreeing to sell for the list price. If you are going to lower the price, you need to follow up any conversations verbally with an email just stating, "Hey, per our conversation, please confirm it's okay for me to lower the price, however many dollars it is." Get them to reply to that email, and then once they reply to that email, you'll be good to go to lower that price. But you don't want to do it without something in writing.
Patrick, there's still nothing on the screen.
Oh, I'm sorry. I'm stupid. Sorry.
No,
Okay.
just
So,
follow.
okay. So again, this section right here is what we're talking about. All right. The term begins on whatever date you begin it on, and it ends. Again, you have to have an ending date. TREC requires an ending date. It cannot be open-ended. Not having a end date is actually a violation that can cause you to lose your license. So, gotta have an ending date. Seller enters into the binding written contract to sell the property before the date this listing begins, and the contract is binding on the date listing begins. So basically, if they already have a listing agreement, this listing agreement will be void. So they're not double dipping. Close that down. All right. So then we have broker's compensation. All right. So again, one of the most important sections because we want to get paid for our work. So whatever percent that you're going to charge them to sell their home goes right here. Please keep in mind that if you're going to split and co-op with another brokerage in the MLS, you got to include both. So mine are 6% or 7 or 8% depending on what I'm doing. If it's a low price transaction, or I'm sorry, a low dollar amount transaction, or it's going to be incredibly complicated, the cost to do business goes up for them. So anywhere, so if you're gonna list for 1%, and because you're gonna turn around and they're gonna buy something, and you're gonna give 3% to the buyer's agent, this needs to be 4%, not just your portion of it. All right. And then if you're gonna have some other rate or bonus added into it, you can put that down here as well. So
Can
again,
we put 6% and then choose later? Do we have to amend this if we choose later to give, to lower it, just to, like, if there's we decide later to give them less money?
like a kickback, it's listed for
No.
it's listed for 6%, but you need to change it to 5% to make the deal happen, that kind of thing.
Yeah.
Okay,
Yes.
so if you do that, then yes, you would need to do an amendment to the residential listing agreement and change that.
All right.
So we see this earned and payable here again. Okay, so when is our commission earned? Okay, when the seller sells, exchanges, option, agrees to sell, agrees to exchange, or otherwise transfer the property, we've earned our commission. And when we or another buyer that we work cooperatively with procures a buyer who's ready, willing, and able to buy the property, or if the seller breaches this listing agreement, as in like they decide a week before closing that they don't want to sell anymore. So when is it paid? Okay, so we got under contract, we're ready to transfer it. Once the closing and funding of any sale or exchange of all the part of the property. Okay, so whenever that happens, if the seller's refusal to sell the property after broker's compensation has been earned, so again, they decide, hey, we're not going to sell it, they breach the listing agreement, or as set forth as otherwise, I'm sorry, at such a time as otherwise set forth in the listing, which we'll get to. Okay, we have down here, so the broker's compensation is not payable, okay, if the sale of the property doesn't occur, but it's not the fault of the seller. So, if the seller, through no fault of their own, is unable to deliver a deed or a title policy as required by the contract, so again, without fault of the seller. So if it's their fault, they're still on the hook, but if it's not, then it isn't. Loss of ownership due to foreclosure. If the seller's failure to restore the property as a result of casualty loss, so if it burns, half of it burns down and they just don't want to repair it, they don't have to pay us. Another portion of this that would be included is if the buyer doesn't close. So for some reason the buyer doesn't qualify for the loan and they can't close, then we don't get paid our full commission. However, this next paragraph right here, D1, almost nobody reads this D1 paragraph. So if your sellers collect earnest money because a buyer backed out in a non-legitimate way, so they get to keep that earnest money, you are entitled to half of that. So if there's a $10,000 earnest money check on the line and your sellers get that, you're entitled to $5,000 of it, less any attorney's fees or collection expenses in order to get it. So if seller collects earnest money, the sales price, or damages by suit, compromise, settlement, or otherwise from the buyer who breaches a contract for the sale of the property entered into during this listing, seller will pay broker after the attorney's fees and the collection expenses an amount equal to the lesser of 1/2, okay, or the amount of the broker's compensation stated in paragraph 5A. So most people don't, the most common situation for this is going to be your seller gets earnest money. Most people don't know this. When I tell people this, they're like, wait, what? If our sellers get earnest money, we get half of it? Yes, you're entitled to half of it, unless it's a big fat earnest money check and the amount, the half is greater than what your actual commission would be, then you're just entitled to your actual commission. And then you still get to keep selling it and you collect more money on the back end. So then we have paragraph 2. So if the broker refers seller or prospective buyer to a service provider, broker may receive a fee from the service provider for the referral. So this is basically home warranty companies, contractors. If you're getting a kickback, this is the notice that you're required to provide them that may happen. Okay, and then other fees and/or reimbursable expenses. What I put in here, okay, and we didn't talk about this on the buyer's rep agreement, so I'm going to touch on it real quick. The buyer's rep agreement does not have a unilateral termination provision for the buyer. So meaning that basically the buyer can't just say, hey, I don't want to work with you anymore. They can say that. We can certainly let them out of their agreement, but we aren't required to do that if there's no unilateral termination. The same thing goes for the listing agreement. There is no unilateral termination for a listing agreement. A seller can instruct you to take it off the MLS. They can instruct you to stop marketing it, but they can't just say, hey, I don't want to use you anymore to sell my house. I mean, they can certainly say that, but we're not required to honor that request because we have an agreement in writing. What I put in this section usually is that if seller terminates listing prior to termination date, seller will reimburse brokerage for all marketing expenses, included in provided receipts or something to that effect. Basically, if they try to terminate the listing before you sell it, they're going to pay you back for at least your marketing expenses. So pictures and postcards and, Facebook marketing, anything that you spent marketing the property, at least you can recoup those costs. So the only thing you're out is time, not actual money.
Repeat that again. Oops. Yeah.
Which part? The whole thing?
Yeah, what you put.
Seller agrees to if seller terminates listing agreement prior to termination date, seller agrees to reimburse brokerage for all marketing expenses as provided in attached receipts. So basically, we're putting them on notice that if they want to terminate and we allow them to terminate, they're still going to be on the hook for paying for all the marketing expenses. Okay, we have our protection period, which we talked about previously. It's pretty much the same. This one goes away if they decide to list it with another realtor. Okay, so again, we have the protection period. If they decide to go, list it again, that goes away. No later than 10 days after this listing agreement, we will provide again the list of all the potential buyers or agents with their buyers that walk through. So if one of those buyers ends up purchasing it, that's what covers us. Okay. All the amounts payable are due in Bastrop, and we have escrow authorization again. Okay. With the MLS, so this says that broker will file their listing within the MLS by the earlier of the time required by MLS rules or 5 days after the date of listing agreement. So within 5 days. All right. This has some information about the MLS and what it requires. And basically this says we're going to report your sold data to the MLS. If you're going to use the MLS to sell, you're going to agree to that whether you like it or not. So a seller can't come back later on and be like, oh, you know what? I know we're using the MLS and we got a buyer, but I don't want to put the sales price on the MLS. They can't do that. They don't. That's not. They're not allowed to say that to you, and you're required to provide the sales data. Otherwise, the MLS will come down on you and fine you, and then possibly take away your privileges. If we're not going to be ready in 5 days, so say we need to, I usually am not ready to go. I don't have sellers that are usually ready to go in 5 days. We need at least a week or two to get everything ready, get pictures done, and get ready to go to market. So if you're going to wait a little bit, we're going to go ahead and say, until 14 days or 21 days or 30 days after this date. And then usually in this blank spot asking why, I just put to prepare property for listing or prepare property to go to market. This just gives you extra time to get that done. Or perhaps your seller doesn't want it to go in the MLS for one reason or another. They're a high profile person. They don't want a bunch of people tromping through their house, so they just want you to kind of sell it via your network. They can certainly select this box and do that. And then we have a notice here that basically says if you don't put it in the MLS, you're not going to reach the biggest range of people. And if you're not going to reach the biggest range of people, you may not get the most money for a house. And that's not our fault. And you understand that it should go in the MLS, more or less. Access to the property. So they're authorizing access, okay, and giving access, our access, other agents we work with access, other people access. They're basically just saying you can come into my home and show it and facilitate the sale. They instruct us to access the property at reasonable times only. They only authorize brokers, their associates, inspectors, appraisers, or contractors to access the property at reasonable times, and duplicate keys to facilitate convenient and efficient showings. So this all has to do with being able to have reasonable access to the property. Scheduling companies. So if you use CSS, this is where CSS would go. If you use something else like Showing Time or something else that you pay for on your own, you can put that in here too. If you don't use anything at all, you just put NA and it doesn't apply. We have a key box. So this basically explains what a key box is, or basically a lockbox, how they work, and alleviates us from any liability should anybody break into lockboxes. And even though our lockboxes are pretty secure, you can still cut one off a door with bolt cutters and then cut it open with a saw. It's not that hard. So broker is or is not authorized to place a key box on the property, lockbox. If there are tenants in there, it's always good to get the tenant authorization for a lockbox release signed by them. They're not required to sign it, but it's nice to get it. It's a good CYA for our file. Liability indemnification. So unless it's our fault, if somebody steals something from them, if somebody gets hurt in their house, if any negative thing that could cause liability happens, we're absolved of that liability unless it's our fault. If we leave all the doors in the house open and somebody comes in and steals stuff, that's on us. I don't know how they would prove that, but that's on us. If we, spill a thing of water on the floor and somebody slips, that's on us. But as long as it's not directly our fault, we're absolved of liability. So then we have cooperation with other brokers. So we will cooperate with other brokers. Okay. And that kind of describes a little bit about what that means. So basically, if another agent brings a buyer for the listing, we'll cooperate with them. And then we have the two different sections here as far as what are we going to offer them. So we had the original price or fee that we charge for selling. This says we're going to share that fee with other agents, and then we put in what amount we're going to share with them. Okay. For me, I'll usually do half or 3%. Here in this box, 3% of the sales price. If it's a sub-agent, I put 1%, because if it's a sub-agent, you're going to do a lot more work and it's going to be a lot more liability for you as the agent. Okay. I also put 1% for both non-MLS brokers. So why do I do 1% here? Well, if I'm selling a property in Austin, and you know what? Let me take it back. We're selling a property in Dallas. Okay. And Kathy's son is going to buy a property up in Dallas, and the son calls the listing agent, says, "Hey, I want to see it," and they show it, and then all of a sudden, Kathy out of nowhere from Houston's like, "Hey, I'll be representing them. I'm on the contract. There you go, and you're gonna have to pay me, yada yada yada." Right? Well, Kathy's not a member of that MLS. So what does that mean? That means the listing agent is going to have to be the one there who's there for the inspection and the appraisal and let the contractors in and let the buyers in to see it again. It's going to be a lot of extra work for the listing agent, right? So the reason I put 1% in here is this. If the buyer's out of area non-MLS agent is not smart enough to get a broker to broker agreement, which we can cover on a different day, I'm only going to be required to pay them that 1%. So that extra money that I have that I normally pay to a buyer's agent, I can do several things with that. I can keep it, I can give it back to my seller, you know, I can do a little bit of both. I put 1% simply for the fact that I don't want to be locked into paying an out of area agent more than what their worth is going to be. So if Kathy says, you know what, my son's going to buy this property, but I'm going to drive up for every inspection, every time they want to get in the house, when the appraiser comes up there, contractors, I'm going to drive up every single time. You won't have to show the property any extra amount. You know what? If I don't have to do any extra work, Kathy might as well be in the area agent. I might say, okay, let's negotiate. I'll pay you 3%. Okay, but I don't want to be obligated to do that for an out of area broker. Does that make sense? Does anybody have any questions about that? Okay.
No.
All right. Intermediary, I'm not going to cover again. It's almost verbatim the same paragraph as it was on the other one. And like I said, we'll do a separate training on this whole topic by itself. Again, confidential information is there. This section goes the entire until the end of time. Okay, unless you're required by law or subpoena or something else to release that information. Okay. Broker's authority. So broker will use reasonable efforts and act diligently to market the property for sale, find a buyer, and negotiate the sale. Okay. Broker is authorized to display this listing on the internet without limitation unless one of the following is checked. So, they don't want it on the internet for some reason. They're super secret government agents and they just don't want it out there. So they don't want it to be displayed on the internet, or they want it to be displayed on the internet, but they don't want the address to be displayed. There's two different boxes for that. I've never had a seller check either one of these. This would severely limit your ability to sell the property, and you'd have to have a really compelling reason to sell your property but not allow me to put it on the internet. So, and then some acknowledgement here that if you don't, that you'll have a limited access to people and you may not get the most money for your house, so on and so forth. Broker is authorized to market the property with the following financing options. Sorry, my brain's fried. Following financing options. I want to say conditions, but it's not the right word. So conventional, VA, FHA, cash, owner financing. You could do other. Other would be like USDA if you're in a USDA area. So that's how we're going to market it. This is a part of our MLS input screen, right? And so then we have these additional authorities that are granted. So they give us the authority to advertise the property by means and methods that we determine are going to sell it. And this means placing advertisements with interior and exterior pictures, audio visual, and any related information in any media form that we think is going to sell. They allow us to place their sign and remove all the other signs offering the property for sale or lease. In Texas, you must have a listing agreement in place before you put a sign in the yard. Do not put a sign in the yard unless they have this listing agreement signed. If they're like, hey, go ahead and put the sign in the yard, we'll DocuSign this later when you send it to us, that sounds good to us. That's verbal. That means nothing. You are technically in violation of TREC rules. Got to have a signed listing agreement before you put a sign in the yard. Okay. It allows us to furnish a CMA and sales information about other properties to other buyers, disseminate information about the property to brokers and other buyers, including the disclosures and notices that we're required to provide. It allows us to get information from any of their note holders, so their banks. It allows us to accept and deposit earnest money in trust accounts, which we do not do. Our broker does not set up for that, which we don't really need to be in this state because we have title companies. Not all states have that, but here we do. It allows us to disclose the sales price in terms of the sale to other brokers and appraisers. It allows us to respond to inquiries from prospective buyers and other brokers. It allows us to advertise during or after the listing ends. The broker sold the property, so we can put, hey, we've sold 10 properties in this neighborhood, and here are the addresses of the properties that are sold. Okay, and allows us to place information about this listing on an electronic transaction platform. Basically, for us, this is MLS and like SkySlope and stuff like that is what that refers to. Very clearly here, broker is not authorized to execute any document in the name of or on behalf of the seller concerning the property. If this would be something that would get me really upset. So do not sign anything for your sellers. If it's something that the seller is required to sign, have them do it. You are not authorized by the listing agreement. You're not authorized by me or the brokerage or anybody else to sign anything on behalf of a client ever. The only thing would be the receipt of option money, which on that form, on the 9th page of the 1 to 4, says seller or listing agent. So it's one or the other. It's not just the seller. So seller's representations. So we're a little bit short on time. I'm not going to go through all of these. You guys can read all of them. If you have questions, let me know. But basically, these are all representations. Basically, they have the legal authority to sell the property. They're not delinquent in taxes. There's no lawsuits concerning the property in play. They're up to date on everything, all the monies that they owe, and that they're, whether or not they're going to use a relocation company. That's basically what these all are here. Sellers' additional promises: they agree to work with us. They agree not to work with anybody else. They agree not to go behind our backs. They agree to maintain the property. They agree that we are working together. So we're not gonna butt heads trying to get this done. We're gonna work cooperatively together. So that's what these sections are right here. Limitation of liability. Again, if somebody comes in and busts their face in their house, not our fault. Okay, if we're showing the property to somebody else, they get hurt, not our fault. If they get sued, it's them and their homeowner's insurance. It doesn't include us at all. All right. And they agree to protect, defend, indemnify, and hold broker harmless for any damage, costs, or attorney's fees or expenses that relate to anything caused by the seller. All right. Or the seller's failure to disclose, or the seller giving correct information to anybody. Special provisions. If you were going to offer a rebate of some kind, you could add that to here. If you were going to turn around and offer them a rebate on a sale because they're going to sell something and then buy something, you could put that information here if you wanted, or anything else that's pertinent to the deal. This special provision sections, again, we are principals. You and I, the brokerage, we are all principals to this listing agreement. So whenever you write something in here, you don't have to worry about the, being an attorney and writing in legal mumbo jumbo, because that's not what this is. You don't want to do that anyway, but nothing that you put in here is going to get you in trouble for trying to, pretend to be an attorney or anything like that, because we are a principal to this contract. Default. So it kind of talks about some default stuff. So basically, if they default, we're still entitled to a commission. If they default on a contract that they have, or if they default on the listing agreement, we're entitled to a commission for the listing price. Mediation. We agree to mediation before we start suing each other. Attorney's fees. If we do sue each other, whoever wins is going to pay those attorney's fees. Okay. Addenda and other documents. So you'll always have a seller's disclosure. Not always, I shouldn't say always. Let me back up. You will usually have a seller's disclosure notice that goes with this. If the house is older than 1978 or built before 1978, you'll have the lead-based paint disclosure. Okay. You will almost always have a real property affidavit, which we talked about in the 1 to 4 training for the addendums and amendments and other forms. If it's in a MUD, you'll have this MUD disclosure. If you want to request information from the HOA ahead of time, you can do that. If you want to request information about their mortgage information, you can do that. Information about mineral causes, septic systems, information about property insurance for the buyer, information about flood areas. If it's a condo, there's a condominium addendum that will go to this listing, which we'll cover in a separate training. Key box authorization by tenant, if there's a tenant in there. And seller's authorization to release and advertise certain information, which we will go over that at a later date, and any other forms that you may have in here. Okay. Some legal mumbo jumbo right here. Okay. This agreement is the entire agreement. They are of legal sound in mind body. They can sign it. If one section was ever ruled to not be legal, all the other ones still stand. It's binding. Sellers are jointly and severally liable for everything in there. Additional notices are very similar to the buyer's rep agreement. Okay, so none of the fees are set. Everything's negotiable. We follow fair housing. Okay. The broker can contact the seller's mortgage company to get any information from them so we know what's up. Broker can put the stuff on the MLS. Broker is advising them to remove jewelry, prescription meds, or any other valuables, firearms, or anything else. So take your expensive stuff and put it away. Okay. We are letting them know that and providing notice that statutes or ordinances may regulate certain things on the property. So like if they have a pool that doesn't have a fence around it, they may have to put a fence around it before we sell. In Austin, we have to do energy audits. That's a requirement for sellers meeting specific criteria. So we're just making them aware of that. If the house was built before 1978, we have a lead disclosure that has to be provided. And that we can't give legal advice, and they should consult an attorney before signing anything. Your name here, or I'm sorry, the brokerage name here, brokerage license number here, your signature, the date, your name, and the seller stuff here. All right. Any questions at all on any of this stuff?
Nope.
Okay, I know we kind of rushed through the listing agreement kind of towards the end there. There's only a few parts that we kind of rushed through. Most of the other ones are very similar to the buyer's rep agreement, which we spent a lot of good time on. Read through the seller representations and seller's additional promises. Those are pretty self-explanatory. If you have questions about those, get with me, and we'll go from there. Otherwise, I'm pretty sure we covered everything here. We'll do a separate class on intermediary to get you guys some information about that, so you feel comfortable with that. And I think that's it. Sorry for the technical difficulties getting kicked off. I don't know what that was all about, but I'm going to figure it out. So, all right, if nobody has any other questions, then we'll be done for today. I will upload these this afternoon, both videos, this one and the first one. And you guys have a good day. Holler if y'all need anything, all right?
Thank you.
All right.
Thank you.
Talk to y'all later.
Bye.